Good morning, everyone. This is Miss S. Kripa Lakshmi, Assistant Professor, Department of Corporate Secretaryship from KCS Kasinadar College of Arts and Science. Today's topic from Industrial Law Unit 2 are Industrial Disputes Act 1947. The subheadings are definitions, authorities under the Act, reference of disputes, and procedures and powers of authorities. First heading definitions. The Industrial Dispute Act 1947 provides essential definitions to clarify the scope and application of the legislation. An industrial dispute is defined as any disagreement between employers and employees or between employees themselves that pertains to matters like wages, working hours, condition of labor, or retrenchment. The Act also defines an industrial establishment as any place, including factories, workshops, or other organizations where manufacturing or production or construction work occurs. The term workman refers to individuals employed in manual, technical, clerical, or supervisory roles except for managerial or administrative staff. An employer is the person responsible for running the establishment and for hiring and paying workers. The term award refers to any decision made by an industrial tribunal or labor court concerning an industrial dispute, including settlements or compromises. A strike involves a group of workers collectively seizing work to push for their demands in an industrial dispute, while a lockout is the employer's refusal to allow workers to work, typically as a response to a strike. Finally, a settlement is an agreement reached between the parties involved in a dispute, which can be formalized through negotiations, conciliation, or arbitration. These definitions establish a legal framework for addressing and resolving industrial disputes in India. Next heading Authorities under the Act. The Industrial Dispute Act 1947 provides for the establishment of various authorities to handle industrial disputes, ensuring effective resolution and promoting harmony between employers and employees. The first authority under the Act is the Works Committee, which is required in industrial establishment with 100 or more workers. This committee is intended to foster communication between employers and employees, helping resolve issues related to welfare, working conditions, and other workplace matters informally before they develop into major disputes. Another key authority is the conciliation officer. He is appointed by the government, whose role is to mediate disputes and assist the parties in reaching a settlement. If the conciliation officer is unable to solve the dispute, the government may establish a board of conciliation. This board consists of representatives from both sides and the neutral chairman, and it works towards facilitating an agreement between the parties. If conciliation efforts fails or dispute can be referred to a labor court, which is responsible for adjudication specific issues such as wages, working conditions, or unfair labor practices. For more complex or border disputes, the industrial tribunal is set up to handle matters that go beyond the scope of a labor court. The industrial tribunal addresses a wide range of issues, including terms of employment, retrenchment, and disputes considering industrial relations. The decisions made by an industrial tribunal are legally binding. In cases where a dispute has national significance or affects multiple states, the national tribunal is formed. It has the authority to adjudicate disputes of national importance, providing final decisions that are binding across the country. Finally, there is an appellate tribunal, which hears appeals against the decisions of labor courts or industrial tribunals. This system of authorities under the Industrial Disputes Act ensures a comprehensive mechanism for resolving disputes at various levels, promoting fairness, industrial peace, and the effective resolution of conflicts between employers and workers. Next topic, reference of disputes. The Industrial Act 1947 of India is designed to provide a legal framework for resolving conflicts between employers and employees in industrial establishment. It defines an industrial dispute in section 2K as any dispute or difference between employers and workers or between workers themselves, considering employment terms, non-employment or condition of labor. The Act includes provisions that seek to resolve such disputes through various authorities such as works committees, conciliation officers, board of conciliation, labor courts, and industrial tribunals. The primary goal is to ensure industrial peace and fairness in the workplace. Moreover, it establishes regulations to govern strikes and lockouts, ensuring that they are not carrying out during the pendency of a dispute or without proper notice. For instance, Section 22 prohibits strikes and lockouts in public utility services like ongoing proceedings, while Section 23 requires advance notice before initiating strikes or lockouts. It also ensures the protection of workers' rights during disputes by preventing employers from making arbitrary changes to service conditions or dismissing employees without the approval of the relevant authority, as outlined in Section 33. By providing clear guidelines and mechanism for dispute resolutions, the Act aims to promote harmony between employers and workers while safeguarding the rights of both parties. Last topic is procedures and powers of authorities. The content is the Industrial Dispute Act 1947 outlines detailed procedures and powers of various authorities tasked with resolving industrial disputes. These authorities include work committees, conciliation officers, board of conciliation, labor courts, and industrial tribunals and national industrial tribunals. The Work Committee, Section 3, is the first level of dispute resolution, consisting of both employer and employee representatives, and is responsible for promoting goodwill and resolving minor disputes within the workplace. Next, conciliation officers, Section 4, are appointed by the government to mediate and attempt to resolve disputes through conditions through conciliations, and if unsuccessfully, the dispute is referred to a board of conciliation, section 5, to further mediate and facilitate settlement. If the dispute persists, the matter may be referred to labor courts or industrial tribunals, section 7 to 7b, which are empowered to adjudicate on matters related to employment, wages, and working conditions, with decisions that are binding. Next, industrial tribunal have broader powers and can address disputes concerning industrial relations on a large scale, including those involving unfair labor practices. The National Industrial Tribunal Section 7b is established for disputes of national importance, typically involving industries with a pan-Indian impact. These authorities have the power to make binding decisions on the dispute, including granting relief or compensation and ensuring compliance with the labor laws. The authorities also have the power to take interim measures, direct the reinstatement of workers, or issue orders on maintaining industrial peace. Importantly, the Act mandates that these bodies must act impartially and expedite the resolution process, contributing to a system that aims to minimize industrial unrest and protect workers' rights while maintaining a fair balance with employers' interests. Thank you. Have a nice day.